Hi everyone, Daniel Chesmore again, and continuing on with civil procedure on the topic of subject matter jurisdiction. Now, subject matter jurisdiction involves a court's ability to exercise power over the claims in the lawsuit. There are 4 ways to get into a federal court. There's what we call the front door, otherwise known as federal question under 1331, 1332 for the visitor's door for diversity, the pet door, otherwise known as supplemental, and the back door, otherwise known as removal, but not a separate basis for jurisdiction. So starting with diversity jurisdiction, federal courts have the power to hear cases between citizens of different states if the amount in controversy is over $75,000. The requirements there must be complete diversity, as in every plaintiff must be a diverse citizen from every defendant. It does not require that all parties be citizens of different states, just that no plaintiff and no defendant can be from the same state. So examined at time of filing, not when the claim first arose. Time of filing, not when claim arose. Remember that? Exceptions, class action, for example. Minimal diversity there, where amount of controversy must be over 75,000, and at least one plaintiff has diverse citizenship from one defendant in the class action. So subject matter jurisdiction continued. Courts have power to hear a case because of the nature of dispute as distinct from its power to enter judgment against a particular defendant. So in state courts, it's determined by the state constitution, state statutes, and judicial decisions. Special states also have a need for efficiency and to fairly adjudicate the cases. Courts of general jurisdiction, general subject matter jurisdiction in state courts. Just because a case is remanded to federal courts does not mean that the state court did not have jurisdiction. So in federal courts, they're governed by Article 3, federal statutes, treaties, and judicial decisions. If not federal questions, we need to satisfy both the amount in controversy, so that's the $75,000 requirement has to be over that, and few statutory instances of exclusive federal jurisdiction, like in bankruptcy, copyright, and diversity, and patent law and IP law cases. Parties cannot waive or create subject matter jurisdiction. Appellate courts review lower courts' decisions but do not take evidence. We do not want to infringe upon state sovereignty. So Congress creates lower courts. Congress can give subject matter jurisdiction to lower courts up to Article 3, but retains power to take away the jurisdiction. Exclusive jurisdiction in federal courts only, limited jurisdiction because of federalism and states' rights, but concurrent jurisdiction in either federal or state subject matter jurisdiction can be attacked at any time in proceedings and collaterally, but not if there was an opportunity to raise issue during litigation. So a federal court can only hear cases arising under Article 3, and only to the extent Congress granted power to do so. So jurisdiction must be affirmatively proved by parties seeking to invoke jurisdiction. Subject matter jurisdiction cannot be waived or agreed to by parties. And so personal jurisdiction is a geographical question, but subject matter jurisdiction is more substantive. The question for subject matter jurisdiction is, should the case be brought before a state or federal court? And remember that federal courts have limited subject matter jurisdiction. States, with exception of narrow cases where the federal has exclusive jurisdiction, can hear any cases they have general jurisdiction. So remember, personal jurisdiction can be waived, but subject matter jurisdiction can never be waived. If a case meets federal subject matter jurisdiction, the state court or federal court, with narrow exceptions. If a case does not meet federal subject matter jurisdiction, then it's going to go to state court. So Congress uses Article 3, Section 2, and enacts statutes describing which cases federal courts can hear. So under 1331, federal cases arising under federal law, diversity cases, cases over which federal courts have supplemental jurisdiction, and cases which may be removed to federal court. So courts have an affirmative duty to ensure that they have subject matter jurisdiction. This can be raised at any time. And remember, it cannot be waived. And so federal courts authorized to hear cases between states, cases between citizens of different states, and cases between citizens and aliens. The framers foresaw a risk of prejudice against out-of-staters or in out-of-staters in state court. So federal courts hear cases that involve application or interpretation of federal law, both from any sympathetic court, protect from any unsympathetic constitution by state courts, and allow definitions, definitive interpretations of federal law. So Congress may not expand subject matter jurisdiction beyond the Constitution, but they can narrow and restrict the kinds of cases a federal court can hear. So Congress can forbid federal courts from hearing certain disputes, even if the Constitution would otherwise permit it. So in diversity under 28 U.S.C. 1332, federal courts should have original jurisdiction for an amount of controversy of over $75,000 and is between diverse parties. So that means, again, citizens of different states, citizens of a state, and citizens subject of a foreign state, unless alien domicile in some other state, citizens of different states in which aliens are additional parties, foreign state as plaintiff, and citizens of a state or different states. And diversity is interpreted to really mean complete diversity. There is no diversity jurisdiction if any plaintiff is a citizen of the same as any defendant. There is an exception, however, in class action suits, which only require minimal diversity. So the burden of proof is the party asserting diversity jurisdiction, and they must demonstrate that it exists. So definition of citizenship for diversity purposes is controlled by federal law, not by state law. So all plaintiffs must be from different states as all defendants. You can't just join parties to an adverse, there are special rules for class actions. You need at least 75 people. Individual citizenship, domicile requires presence and intent to remain. And domicile is retained until a new one is established. Residence is usually a physical place. So in the Mass versus Perry case, citizenship is your domicile. Mere residence is not sufficient for diversity purposes. Person's domicile is a true, fixed, and permanent home and principal establishment, and to which he has intention of returning whenever he is absent. Change of domicile can only occur by taking up residence in a different domicile and intending to remain there. So in that case, Perry, moving to location for grad school was not viewed as a change of domicile. You are domiciled at the last place, and that meets the definition. So in Strawbridge, limited 1332 to complete diversity between opposing parties. Remember that citizenship is based on domicile, not just residency, and it's determined on the day, actually, the action is filed. Parties cannot join just to get jurisdiction there. Corporations, both where it is incorporated and where its personal place of business is. So there are two tests. There's a nerve center headquarter test, and then the muscle test, where activities and where their operating assets are, or total activity. It's like a holistic hybrid. So alien permanent residents use domicile. Stateless aliens are banned. Unincorporated association, citizenship of its members, representative actions, class actions, or derivative suits. Citizenship of representative, not represented. Nominal parties are irrelevant, and there must be complete diversity among the parties for Strawbridge. If there's a non-diverse party, you have to ask if there's a federal question claim, then it might be okay, and that would be separate grounds for subject matter jurisdiction. So citizenship is domicile, as we said, place of permanent establishment with intent to stay. Citizenship of a corporation is all states where they're incorporated, and the one state of the principal place of business. Citizenship of unincorporated business, partnership, or union, citizenship of its members, citizenship of a class, citizenship of class representative. All diversity cases excluding federal question by diversity are decided under state law, since not federal question. And so big picture there is that to protect out-of-state defendants allows federal government to weigh in on some big interstate cases affecting, or maybe perhaps under federal question jurisdiction. But for diversity, you need to be at least $1 over $75,000. And every plaintiff must be diverse from every defendant. So here's an example where you've got different states. I wrote this in cursive Hebrew, but they've got Other examples here where you've got all of them are from, they have to be different from one another. So here, this example wouldn't work if we've got states A, B, and C, and then defendants from also A, B, and C. We need complete diversity on both sides of that equation. So there is the U.S. Citizen Expact can sue any defendant because they're in a different country, in a state. Actual presence in state plus facts showing intent to make that their permanent home there. That's a requirement for diversity. Domicile depends on subjective intent. So determining citizenship under 1332A1, they're natural persons, U.S. citizens, and this would be their domicile with the actual presence in the state and intent to make it their permanent home. For corporations, we said that it's their place of incorporation and the nerve center, the place where they centrally operate, where maybe most of their assets are. Partnerships, LLC, LLP, where any partner or member is a citizen under the partnership. So Hertz gives a nerve center test for corporate citizenship, where corporate controls involves decision for the organization. Natural persons cannot be domiciled in more than one place like a corporation. They're incorporated in Texas, for example, but they may operate in California. But dual citizens, nothing to do with determining citizenship of diversity jurisdiction. You can aggregate unrelated claims to justify that $75,000 amount requirement. Freeland failed by 1 cent because you have to be over $75,000. And remember, this is more than, not more than equal to. So that's something to note for the bar. It has to be at least a penny more than $75,000. Amount in controversy, basic rules. Basic rule is that if a case involves a single plaintiff suing a single defendant, plaintiff can aggregate as many claims as she wants to satisfy the amount requirement, even if they are unrelated. But if there are multiple parties on either side of the case, aggregation is not allowed unless the claims are jointly held in case of multiple plaintiffs or jointly shared in the case of multiple defendants. And so is aggregation okay to meet $75,000, that requirement? If we've got a plaintiff versus defendant, aggregation of unrelated claims against the defendant are okay. If we've got a plaintiff versus two defendants, aggregation is okay if the defendants are jointly liable for the same claim. So you might have a contract claim and a torts claim against the defendant. Both those can be added even if they have a different cause of action. However, if you've got multiple defendants on one side and just one plaintiff, to meet diversity, those claims have to be jointly liable for the same claim. So maybe they both breached a contract, or maybe they both committed a tort. I think the tort is a more fun example where both of them are negligent. They share the negligence, like contributory negligence, and or comparative negligence. And then in that case, that would be okay to be aggregated to meet that $75,000 requirement. If you've got multiple plaintiffs versus a single defendant, aggregation would be okay if they're jointly held by the plaintiff. So if the plaintiffs are joint tenants and there was a developer who destroyed a home, then that might be okay if they have separate damages. Maybe they're in a duplex, or not as joint tenants. So maybe they're separate. Maybe they share parts of a structure, and then there's some tortfeasor who destroys the full building, and they each lose half their interests, and so they each sue for $40,000. That aggregates to $80,000. That's okay. So for example, that example of plaintiffs jointly own real estate and sue defendant to quiet title, that's a great example. Separate plaintiffs are joining together to enforce single title or right, which they have a common and undivided interest. For example, is a situation where all plaintiffs are tenants in common with respect to a single piece of real property. You can't include costs or expenses to litigate. Amount in controversy is about the claim. So plaintiff will always be taken of his word so long as they stand the amount in good faith, unless legal certainty that there's no way they can recover that amount. Requirements, there is to be more than the $75,000, but in controversy, but where plaintiff recovers more than $75,000. Not where the plaintiff recovers $75,000. Just a good faith that their claims are at least $75,000. They might not get $75,000 in the long run, but that won't defeat the amount in controversy. Corporate citizenship is determined by the state of incorporation, principal place of business, determined by the nerve center test per Hertz, where major business decisions are made. Unincorporated associations, citizens of every state where there is a member. Amount in controversy, satisfied by good faith estimate by plaintiff at the time of filing, excluding interest. AFA TORS is a good case. Aggregation of claims, single plaintiff, single defendant, all aggregation is okay. Multiple plaintiff, single defendant, aggregation okay. Were claims related by some sort of jointly held or common cause of action. Single plaintiff, multiple defendants, only claims which are, in that case, jointly held, jointly liable. So we look for joint liability there. And where defendants are jointly liable, that's okay. And there's an ExxonMobil case, which we'll get into later on if we have time, just going over the general concepts. If named plaintiff reaches amount in controversy, other smaller claims in the same case, controversy may be joined for efficiency. Amount in controversy must exceed the $75,000, excludes interest and costs. So dismissal if legal certainty that threshold is not met. Can include punitive damages, statutory attorney's fees, and injunctive relief, but not that interest and costs piece. Aggregation of claim amounts allowed for our plaintiff, one defendant for single irreversible harm or indivisible harm. Class action requires an aggregate total exceeding the $5 million for a class action. So we've got a lot to cover here. Hopefully we can get into the cases under an hour before we move on to the next half of civil procedure. But tests for the principal place of business per Hertz, that nerve center test, justified by administrative simplicity, where they're held to, where their jurisdiction exists, vested economic interest in using a predictable standard, typically the headquarters, but maintain essential functions. Other tests, corporate activities, operating assets tests, greater location of corporate production activities, total activity tests, hybrid of previous two, considers all circumstance surrounding the business. Some claim by plaintiff controls made in good faith must appear with legal certainty, then the claim is less than the jurisdiction amount. If punitive damages permitted under controlling law, then they're included. Court must afford appropriate reasonable opportunity to show good faith that meets the requirement. Injunctive relief can still qualify based on an estimate of the value of the relief. So aggregating claim amounts, each plaintiff must satisfy the requirement. Exceptions there, multiple plaintiffs in a single suit may aggregate the amount of claims they seek. To enforce a single title or right in which they have a common undivided interest, for example, two partners, owners of business, property, not class action, but one plaintiff can aggregate all claims into one suit to meet requirement when these claims share nothing in common besides identity of the parties. So indemnification, joinder, and diversity. Defendant suing another party under Rule 14 for indemnification does not destroy diversity unless the plaintiff amends the complaint to add a claim against the new defendant. For purposes of subject matter jurisdiction, it is treated as a separate suit or claim. So impleader claims must arise from same set of facts as they may claim to satisfy Rule 14. So will necessarily meet the requirement in that case, United for 1367A, that we'll talk about supplemental jurisdiction, and that Kroger case. So here, that rule is that plaintiff's claim of damages governs unless the defendant shows to a legal certainty that claim does not meet jurisdictional requirements. In the AFA case, where it sues defendant, customer lists to aid new tour business, court dismissal for failure to meet amount in controversy, but the Supreme Court reversed. In AFA, the court applied the rule for St. Paul Mercury, placing the burden on defendant to prove with legal certainty that plaintiff's claim is really below the $75,000. Result in AFA is that any claim that has a good chance of exceeding the requirement will be treated, but tempered by court's ability to actually adjudicate if the claims turn out less than the $75,000. What plaintiff recovers is irrelevant since jurisdiction attached when claim is made. So aggregation, adding parties and claims for purposes of exceeding jurisdictional amount. There's a rule from Zahn. Single plaintiffs can aggregate claims against single defendants. Multiple plaintiffs may not aggregate if they separate and divide those claims into distinct claims, but if there's a single indivisible harm, then they may actually aggregate. One plaintiff may not aggregate claims against multiple defendants unless the defendants are jointly liable for the same claim. Class action fairness allows aggregation of individual claims to meet $5 million amount in controversy requirement. Injunctive relief remedies, dollar amount, there are 3 approaches. In the plaintiff's view, does what defendant is doing the damage exceed $75,000 regarding the damage to plaintiff? Defendant's view, would it cost defendant more than $75,000 to comply with the injunction? Either view tests a pecuniary result to either party, which judge would directly produce there, what judgment would directly produce. And under AFA, before dismissing a federal diversity suit on grounds of insufficient amount of controversy, there must be an action which allows a plaintiff the opportunity to show the claim has been made in good faith, and the plaintiff can brief that issue. And so we'll talk about that more when we get to some of the settled case law there, and then we'll end with the Erie Doctrine, and then if time allows, we'll get into some of these cards just to read some of these cases. They might be helpful. So issue of amount in controversy must be raised at the outset. Action must follow plaintiff a reasonable opportunity to show the claim amount was made in good faith. There's a federal question jurisdiction rule, the front door. Federal district courts have original jurisdiction over property, properly placed claims that arise under federal law. Note, no diversity of citizenship or amount of controversy requirements under the federal question. And in the notes there, federal courts have jurisdiction over all cases arising under federal law because the matter to be decided is a question or issue of federal law. Where either the plaintiff or defendant raises raises a legal issue, the court must refer to federal law in order to decide. Plaintiff may raise violation of federal law, as litigant may claim federal law as a defense, but doesn't look at citizenship at all, only looks at the substantive nature of the claim. State courts can also hear cases arising out of federal laws. They have general subject matter jurisdiction, except where the cases are exclusively federal jurisdiction, but they cannot hear cases exclusively federal jurisdiction there. Federal courts have the authority to hear civil actions arising under federal laws, treaties of the U.S., whether an action arises under federal law, by the well-pleaded complaint rule. Well-pleaded complaint rule is for a case to arise under federal law, a federal question must appear on the face of plaintiff's properly pleaded complaint. The right or immunity conferred by federal law must be a basic element of the plaintiff's claim. Matters insufficient to trigger federal question jurisdiction. Case ordinarily does not arise under federal law if defendant, not plaintiff, involves federal issue, or if plaintiff's complaint anticipates a defense based on federal law, like per Louisville. Also not enough if plaintiff's assets are a state law claim requiring interpretation of federal law. It has to really arise under federal law, not just have a defense that relates to federal law or sub-issue. The case really needs to be based on federal law. For federal question, district court should have jurisdiction of all civil actions arising under the Constitution, laws, or treaties of the United States. State courts can also hear cases arising out of federal law. 1331 does not grant exclusive jurisdiction. State courts can also hear issues involving federal laws. So in the Osborne case there was a lawsuit in Ohio for collecting taxes, and federal law trumps state law there. It prohibits the state from imposing a state tax if it's arising under, because it was a state tax that was constitutional. Marshall did say that mere presence of federal issue, as long as federal issue is ingredient, then suffices to invoke federal question jurisdiction in the ingredients test. Congress, through 1332, narrowed the scope of cases that can be heard. District courts shall have jurisdiction. An asked limits on federal question tests is the Osborne test, where any question sufficient or is some other limits being imposed, then yes. Federal question there involves cases infecting ambassadors, admiralty, maritime jurisdiction, and controversies to which the U.S. is a party. So well-pleaded complaint rule again, court looks at only the complaint, not anticipated defenses or later counterclaims or cross-claims to see if this issue invokes or involves federal law under Louisville. In Louisville, that was a case involving breach of contract by a railroad company to provide free transit after Congress based that act forbidding such agreements. The court held that at its core, it was merely a breach of a contract dispute with state law claims. Suggestion of one party that other will or may set up a claim under the Constitution or laws of the U.S. does not invoke the suit or arising under the Constitution of these laws. So what to look for on the face of the complaint: an express violation of federal law, most common or simple case, implied cause of action created by federal law, the Holmes case, no longer used, however. Proper forum to hear a case is one having control over laws which created the cause of action. Where state law creates cause of action, federal jurisdiction typically not appropriate. For example, in another case, the dispute, it was in ownership of copyright. It was a state law issue instead of copyright itself, which would be a federal question. So in Louisville, plaintiff's claim must arise under federal law. To determine whether it's a federal claim, court looks to the face of plaintiff's complaint itself when alleged breach of contract, not to anticipated defenses. The well-pleaded complaint rule. So is the plaintiff trying to enforce a federal right? Authority from 1331 arising under constitutional laws, treaties of the U.S. We want a uniform adjudication. We want to avoid biases. Federal courts have expertise in federal law. Cause of action must itself give jurisdiction. Plaintiff cannot use federal courts based on anticipated defense or counterclaim. In the Louisville versus Motley case, a promise to give free passes breached because of there was a new federal law. Well-pleaded complaint definition jurisdiction, but pleading to obscure due and that was banned there. So always look for the well-pleaded complaint. Federal law created property as an ingredient of the claim. It was not the same as arising under. So not just ingredients, it has to really arise under. So Louisville, federal question is determined by the cause of action. Just because they may be federal law someplace within does not mean we necessarily have federal question jurisdiction. Federal law must be a cause of action. So under 1337, unfair practices and import trade, for example, 1338, federal patent law, 1343, federal civil rights statute. So in Osborne, the court interpreted congressional authorization of banks issue to be conferring federal subject matter jurisdiction. Act of Congress Foundation. Without it, contract could not have been formed. Ingredients test, broad authority to confer federal jurisdiction if federal law is an ingredient. Even a small one is one theory. States have concurrent jurisdiction over federal questions, but then it was later ruled that this was kind of overly broad. Takes us to Gravel. There might be a substantive federal interest, which may be more important than requiring federal cause of action. Gravel. A case may arise under 1331 in three ways. Federal law creates a cause of action. Plaintiff's relief in a state law matter turns on a federal issue, and the suit must be a substantial claim founded directly under federal law or directly on federal law. That Gravel test is a federal issue sufficiently important, substantial enough to be heard by federal courts. In Gravel, it was federal tax litigation and the need for federal experience / uniformity and the danger of flood litigation. There's also the Merrill-Dow test, is exercising a federal question jurisdiction consistent with congressional intent. In Gravel, the question is, does state law claim necessarily raise a stated federal issue, actually disputed and substantial, which a federal forum may entertain? Any congressional apparent balance of the federal, state judicial responsibilities. And so here we get to an allegation, anticipated constitutional defense and complaint, but that did not give a federal question jurisdiction, diversity of citizenship between litigants. There was no diversity there. What do we look for on the face of a complaint? The well-pleaded complaint rule. Or express violation of federal law, that's usually an easy case. Implied cause of action created by federal law, we do the Holmes test. Suing under state law, but necessarily turns on federal law, that's a Grable. Federal government is a party, that's Osborne. Federal right interpreted through state law. Those are all examples of arising under federal law for federal question. And Grable, the three-part standard is the Holmes test for determining if a state law claim has a federal issue. We ask, does a state law claim necessarily raise a federal issue? Is the federal issue actually disputed and substantial? And is federal jurisdiction will not disturb any congressionally approved balance of federal and state judicial responsibilities. Arising under jurisdiction allows federal court to hear claims that through substantial questions of federal law, substantive, and this justifies that exposure, solidifies uniformity of a federal forum. In Grable, the court determined that there was strong national interest there in interpreting IRS tax provision despite lack of federal cause of action. So may a federal forum entertain issues without that balance of power beyond federal state cases? It's a category of cases, but it's extremely rare. So approaches, any of these will work. Federal question must appear on the face of the complaint. That was the Louisville case. Is a federal claim a cause of action in a plaintiff's complaint, not merely raises a defense or extraneous for targeted allegations? Remember, federal law created the cause of action under the Holmes creation test. The claim must show a right or interest founded in federal law, not state law. And the state law claims turning on a substantive federal issue like Grable. Case necessarily raises a federal issue. Federal issue is actively disputed and substantive. Federal jurisdiction will not disturb any congressionally approved balance of federal and state judicial responsibilities. So remember, we look at citizenship at the time when filing the lawsuit, not when the claim or the accident first occurred. It's when the lawsuit is filed. So you can have it so that you could have a plaintiff and a defendant who are originally part of the same state, but the plaintiff moves to another state. And you could have, and then the plaintiff subsequently files suit, and then they would have that diversity jurisdiction. The timing, I think, would make for a good multiple choice question. Courts and Gunn said not enough that federal issue be a significant part of the case. Rather, federal issue has to be so substantial, meaning that determination of state law claim is going to be completely dependent on the federal question. In Gunn, state law claim may be adjudicated in federal court if state law claim raises a federal issue that is actually disputed and substantial, and the federal court's hearing of the case does not disturb the congressionally mandated balance of federal and state responsibilities. Framework for federal question jurisdiction: you want to identify the plaintiff's complaint, identify what their cause of action is in the complaint for the plaintiff, use that well-pleaded complaint rule, use the creation test, but under federal law or statute for existence of federal law. If yes to number one, then you'll use the Grable test. And then if the state law cause of action is in plaintiff's cause of action and complaint, ask if it satisfies Grable, where if yes to number two, then federal question is met. But if no to number one or two, there's no door to federal question jurisdiction, so you have to go through diversity jurisdiction. Federal courts have exclusive jurisdiction over bankruptcy, patency and copyright, antitrust, admiralty, Securities Exchange Act, and cases where the U.S. is a party. Oh, excuse me. So supplemental jurisdiction. Ooh, it gets really fun here. So with supplemental jurisdiction, it only applies to subject matter jurisdiction, doesn't satisfy personal jurisdiction or service of process. This is used to get claims lacking that amount in controversy, federal jurisdiction into federal court. So this is, you have a pendent complaint, an ancillary counterclaim or cross-claim jurisdiction for claims that lack subject matter jurisdiction on their own. Rationale is judicial efficiency, fairness, convenience for litigants to not have to choose between claims because courts really want to settle everything at once. But we look for this common nucleus of operative fact to determine a constitutional case. So state claims of unlawful conspiracy supplementary to allegations of I forget what that. This was a case that violated some labor act. It was codified in 1367A. In 1367C, there's discretion to court depending on weight or novel of state claims, risk of injury, confusion of the issues, etc. It was an executive there. Limits placed on United Mine Workers to avoid pendant party jurisdiction overruled by 1367 that allows for multiple claims and multiple parties. So diversity jurisdiction is still necessary, though. It's codified in 1367. An ancillary claim is not allowed by plaintiff under Rules 1419, 20, 24, or a new plaintiff under Rule 19 or 29, or they violate 1332. So it's allowed for Rule 13, compulsory counterclaims, Rule 20, permissive. Remember that a plaintiff cannot use supplementary jurisdiction to get joinder of new plaintiff. That is, you can't use impleader, joinders, or interveners, but a defendant can. Supplementary claims do not have to meet a mountain controversy requirement. But the plaintiff must have diversity or federal question jurisdiction based onto federal courts. Every claim asserted, plaintiff must have federal statutes there. Seems every claim must invoke diversity of federal question jurisdiction. Supplementary jurisdiction is a method in which plaintiff can get a non-diversity, non-federal question claim into court, federal court. It's our friend. So first, you need to anchor the claim in 1331, 1332. As a general rule, supplemental jurisdiction is proper, where the state constitution grants jurisdiction over entire cases, not issues, if the case must include at least one claim that federal court has jurisdiction over, and all claims must derive from some from that nucleus, from that common nucleus of operative fact. And so that makes sense to try them all in one proceeding there. And when we look at common nucleus of operative fact, we look at same facts, same evidence, witnesses, etc. Under 1367A, as long as a federal court has original jurisdiction over the case, 1367A grants broad statutory authority to hear related state law claims that arise from the same case or controversy. Under 1367B, that applies to complete diversity and not federal question. So you cannot destroy complete diversity with supplemental claims, but only one plaintiff need meet the amount in controversy. Supplemental jurisdiction is discretionary. Courts can decline supplemental jurisdiction if there's a novel or complex issue of state law. The state law claim substantially predominates over the federal claim. Original jurisdiction claims get dismissed. State claims will go too. And exceptional circumstances where we also look at jury confusion, judicial economy, convenience, and fairness. So almost there, where we'll discuss a little bit more on supplemental jurisdiction and some of these related rules. Before we move on to removal, we still want to discuss issue and claim preclusion. And then moving on there. So diversity claim there. Remember federal question claim, Finley held that even when we exercise a federal question over a federal claim there, would allow Supreme Court no jurisdiction over unrelated non-federal claim against some non-party, non-diverse party. And so this would allow plaintiffs to circumvent complete diversity requirement. And so that's why we have this rule from United Mine Workers versus Gibbs. Courts have discretionary power to hear jurisdiction in sufficient state claims deriving from a common nucleus of operative fact, in which there is a substantial federal issue. 1367A grants supplemental jurisdiction over all claims that form part of the same case or controversy under Article 3. Case or controversy embraces everything with a cause, with a common nucleus of operative fact. 1367B prohibited use of supplemental jurisdiction when cases based solely on diversity jurisdiction is insufficient claim by a plaintiff against persons made a party under Rule 14 for third-party plaintiffs, Rule 1920 for permissive and compulsory joinder, and Rule 24 for intervention. If defendant's counterclaim is compulsory under Rule 13A, courts will allow ancillary over counterclaim. If counterclaim permissive under 13B, then it will not. 1367A grants district courts discretion to decide to exercise supplemental jurisdiction if the state-based claim is novel and complex, or or really guts the action. Federal question claim has been dismissed. Must establish original subject matter jurisdiction before we can establish supplemental jurisdiction. There are 3 steps to approach analyzing supplemental jurisdiction. Does the court have the constitutional power to hear the supplemental claim? Has Congress authorized jurisdiction over a related claim, like joinder exclusions? And does it fall under discretionary factors allowing a court to deny supplemental jurisdiction? So supplemental jurisdiction, common nucleus of operative fact, jurisdiction over all claims so related in action within original claim that they form part of the same case or controversy. We have exceptions there. Where supplemental jurisdiction does not exist over following claims of parties. Claims against defendants joined under Rule 14, 19 for required joinder, for 20 for permissive joinder, and 24 for intervention. So claims by plaintiffs joined under 24, discretion to decline. District court may decline to exercise supplemental jurisdiction if the state claim raises novel or complex issues of state law. There's a state sovereignty basis for that. State claims substantially predominate over the actual federal claim, and all claims over which the court originally has jurisdiction have been dismissed. Any other exceptional circumstances, such as if a jury might cause jury confusion of federal or state law. So why restrict supplemental for Rule 19 for required joinder but not 20 for permissive joinder? Well, it's abstract. Cases conceived of one party, one defendant, one case in Brennan's view. But in practice, Rule 19 parties are essential to a case, so multiple plaintiffs or defendants may be in the case. Under other views, permissive parties are not essential to case. Hooking them in under supplemental jurisdiction does not violate notions of diversity. So pendent claims jurisdiction, federal courts may decide state issues which are closely related to federal issues as being litigated under the common nucleus of operative fact. Gibbs dismissed that notion that single cause of action is essential or correct assessment as whether in a broad sense there is a common nucleus of operative fact, we'll call it CNOF, to satisfy res judicata, a matter of, we'll talk about that later. Article 3, Section 2, extends power to all cases, court claims, Brennan versus this is all one case that in part arises from federal law. Court has the discretion for pendent jurisdiction, must evaluate based on judicial economy, convenience, and fairness to the litigants. In Midringer, implication in pendent party jurisdiction is allowed under Congress, unless Congress forbids it. For the past historical approach, under Howard, court refuses to bring in additional party under pendent jurisdiction when no independent basis of federal jurisdiction. Party couldn't come in under that federal question jurisdiction. Supplemental jurisdiction may not be used to join defendant that federal statute specifically does not have case of or cause of action against. So represents first pullback from United Mine Workers versus Gibbs. Federal courts may decide state issues which are closely related to federal issues being litigated for a common nucleus of operative fact. Gibbs brought suit arising and alleged 1, claim under 303 for some sort of federal, is completely federal, and 2, some common tort claim under state law. That was what they wanted to bring under supplemental. And prior to Gibbs, the state claim would have to be filed separately and tried in state court, no federal issue, and diversity citizenship to make it into federal court. But the impact supplemental jurisdiction granted where there's CNOF in cases would normally be triable and together. CNOF abandons the transaction and occurrence under 1313, and court is about trying like things together, like cases together. So in Gibbs, there was a contracts case. He lost his job and sued for violation of a federal act and state claims for contract, business, and interference. Under pendent jurisdiction, federal courts may decide state issues which are closely related to federal issues being litigated. Under pendent jurisdiction doctrine, granting authority to federal court to hear a claim that does not involve diversity jurisdiction if it arises from the same transaction or occurrence as a primary action. Issue of pendent jurisdiction properly assumed there is open throughout litigation. If federal law dismissal, state claims should also be dismissed. Now, because of Gibbs, state and federal claims can state separate causes of action so long as they're federally closely related. So federal court can exercise penitent jurisdiction over state and federal claims if federal and state claims are the type that would be expected to be heard at a single hearing and are derived from a common nucleus of operative fact. Their court may hear claim there grow from same factual background, and they constitute that. 1367A conditions grant of supplemental jurisdiction on court's discretion if claims raised a novel or complex issue of state law, if state law is the predominates over federal law, or if federal court has dismissed all federal claims. If others, then there are compelling reasons. So in this example, someone from Iowa sues someone from Nebraska. There's an electrocution, sues in federal court under diversity. However, cannot bypass complete diversity where defendant joined third-party indemnifier who was not diverse, then stepped away. Supreme Court here refuses penitent jurisdiction when no independent basis of federal jurisdiction, partly couldn't condemn federal jurisdiction. It was a federal question. Convenience of litigants and judicial economy cannot justify extension of supplemental jurisdiction over non-diverse defendants. So in Finley versus United States, led to enforcement of 1367, Congress must explicitly authorize pendent party jurisdiction for federal cause of action in the case for supplemental jurisdiction to be applied. Where the plaintiff husband toiled, there was some sort of U.S. negligence case there. Pre-finding pendent jurisdiction is allowed unless Congress explicitly forbids it. Post-Finley, pendent-only jurisdiction is forbidden unless Congress expressly allows it. So here Finley brought partial diversity suit. Original claims was under federal statute, amended to include state tort law claims. In federal courts that all our cases have held that grant of jurisdiction over claims involve particular parties does not itself confer jurisdiction over additional claims by or against different parties. Supreme Court essentially said they know that this isn't the right solution, limited Congress to rule within 1 year of 1367 being enacted. Under the Marxist approach, ExxonMobil, and Alphabeta Services, if a court has jurisdiction over a single claim in the complaint, then it has jurisdiction over the entire civil action. Class representatives had a mounting controversy, but the rest did not, and requires complete diversity despite supplemental jurisdiction. Otherwise, jurisdiction could nullify a complete jurisdiction requirement. Diversity 1367 overturned Finley, but retained limits, suggesting in Kroger against using supplemental jurisdiction to circumvent the diversity requirements. Under Rule 20, there's an exception in 1367B, which prevents joining non-diverse defendants, but not plaintiffs. However, cannot use supplemental jurisdiction to join non-defendant plaintiffs under 1367. B, because inconsistent with judicial requirements under 1332. So there, we also have the amount in controversy. Supplemental jurisdiction may be used if at least one plaintiff satisfies the amount in controversy requirements for diversity. Different because of diffuse amount in controversy is statutory, but complete diversity is constitutional request for Article 3, Section 2. Where one plaintiff claims satisfies the manner about confronting requirement for federal jurisdiction, and another plaintiff's related claim does not, 28 U.S.C. 1367 allows federal courts to exercise supplemental jurisdiction over the claim that is less than required amount. Overruled Xeon, which held in Zohan that all of the plaintiffs had standing. Exxon Exxon overruled Zahn, which held in Zahn that all plaintiffs had to satisfy the 1332 amount in controversy requirement. And there, the Gravel test. State law claims success will turn on an interpretation of federal law. So supplemental jurisdiction will always involve a state law claim, but it can never be a federal question claim. So on exam, you'll say that the common nucleus of fact is satisfied as a supplemental claims arising from the same transaction or occurrence. Discretionary factors: a court may refuse to exercise supplemental jurisdiction if the state claim raises a novel or complex issue of state law. State law issue substantially predominates over the case. District court has dismissed all claims over which it has original jurisdiction, or any other compelling reasons. So steps for supplemental jurisdiction analysis: first, you got to rule if that state law has a common nucleus of fact as the main claim that satisfies federal question or diversity jurisdiction. And if the main claim invokes diversity jurisdiction, do any 1367B prohibitions apply? And if not, do any discretionary factors in 1367 apply that allow the court to decline exercise of supplemental jurisdiction? So almost there. We've got a lot to cover here. I think we'll have to go over an hour for this video. And I think it'll be 2 more hours to cover the next part of civil procedure. It's pretty lengthy when we get to pleadings and all that. So notice of removal: federal courts or consent to such removal within the applicable 30-day period. As with any case filed in federal court, first, a case removed from state / must go to federal court must include federal causes of action. So removal is the backdoor, 1441A, where a defendant can remove a case originally filed in state court to federal court if the federal court would have had subject matter jurisdiction, such as diversity or federal question. There are limitations. You can only remove if the case could have been filed under federal court under 1441A. Only defendants can remove 1441A. All defendants must agree to remove. For 1446B2A, can only remove to federal district embracing the state court in which the case was originally filed. And remember, the plaintiff can't remove to federal court. Can only remove to federal district embracing the state law in which the case was originally filed. And defendant filed permissive counterclaim in state court waives that right to remove. When you file a permissive counterclaim in state court, you waive your right to remove. And remember, this is only defendants. So timing and procedure, 1446. Defendant must remove within 30 days of service of process. So within 30 days of getting that complaint, you're going to have to remove. You must file a notice in federal court, then file a copy in state court. Signaling all the defendants containing grounds for removal. Notice must be provided to all adverse parties. Diversity jurisdiction limitations. No home state removals there. No removal if any defendant is a citizen of the forum state. 1441B2. No removal more than 1 year after the case is filed in state court for 1446C1. Note, most cases will be removable when the case is filed and defendant is served with process. Defendant has 30 days to remove for service. So this 1 year provision only applies in cases that were not removable when filed but became removable later if plaintiff voluntarily dismisses a non-diverse defendant. Exception: plaintiff acted in bad faith to prevent the defendant from filing a timely removal. So I'll pause there so you can take a look. and look for remand, where if removal was improper, the court can remand to state court under 1447C. And so lack of subject matter jurisdiction, a plaintiff can move to remand, or court on its own can motion at any time. Improper removal procedure there, a plaintiff can move to remand within 30 days after the filing of the removal. So removal of civil actions, 28 U.S.C. 1441. Any case that could have been brought in federal court can be removed from state court. At home, defendants cannot remove. Defendant may not remove to federal court if a defendant is a citizen of the state in which the action is brought. All defendants must consent to removal. Where an action involves both federal and state claims, a district court may sever the claims which it would not have independent jurisdiction over and send back to those state courts for remand or removal. So exception, class action suits where any defendant can remove without consent of others in state defendants. Removal jurisdiction allows for original defendant to transfer from state court to federal court and to even the playing field to a natural forum. All defendants must agree to remove, exceptions being made being misdemeanors or class actions, and remand is argued in the new forum. 1441A, removed to federal court that plaintiff would have brought, has jurisdiction for diversity cases. 1441B, parties cannot be a citizen of the state to remove for diversity cases, 1441C, one removable claim can remove the entire for federal cases, federal question cases. There must be a separate independent claim, but this allows for courts to hear even more than 1367. Court has discretion and can send all or part of the case back to state court. So there, we'll keep continuing. Under 28 U.S.C. removal, remember there, removal is a device by which defendant has a case in state court, remand to federal court. It's really a transfer that we think about, but we do not call it that. We just call it removal. Transfer of a case by defendant from state court to federal court. Statutory exception for the plaintiff being the master of his claim. Federal court is intended to protect both parties, so both should have access there. (1441A) can only be removed if federal court has original jurisdiction. For federal question diversity, can only remove to federal district court for the state court where the action is pending. For the state where the action is pending. So if original jurisdiction is found on diversity, cannot remove to federal court in a state where any defendant is from. It destroys the diversity there. So if original jurisdiction is found on federal question, can always remove to federal court. Under 1441C, if the federal court's original jurisdiction is based on 1367, for supplemental jurisdiction, it has supplemental jurisdiction over state law claims removed also. So claims stay together when removing. Exceptions would be the West case for the Third Circuit, the state law claims that do not arise from the same common nucleus of operative fact as a removable federal claim can be removed along with federal question claims. This is unconstitutional under Gibbs, but hasn't been tested yet. 1441F, if state court lacked jurisdiction, but federal court has original jurisdiction, case can still be removed. Removal of civil rights cases federal courts includes all equal rights cases. 1446, procedure for removal must be filed within 30 days of that service of process. Procedure after removal from state to federal court. Challenging subject matter jurisdiction. This is offense to claim of jurisdiction as a special appearance. Any interested party can seek dismissal of subject matter jurisdiction at any time. If the case is dismissed, it can be refiled in state court. So a pleading requesting relief from jurisdiction must include a reason why, exception to res judicata there. So removal to federal court. 1441 authorizes defendants to remove jurisdiction claims from state court to federal court. There's one way to do it. Can only remove an action that could have been brought in the federal court originally. Basis for federal jurisdiction must appear on the face of the complaint. Only the original defendant can remove. Way of protecting federal forum shopping. Plaintiff has the burden of remanding to state court if he wishes. So there's removal and then there's remand. They're distinguished, as we talked about. Diversity cases, only defendants who are non-citizens of a foreign state can remove. If there are multiple defendants, all must be non-citizens of a foreign state to remove. Diversity case cannot be removed if there are multiple claims and at least one is not removable. In a federal question case, an action is removable by any defendant, regardless of party citizenship. Under 1441C allows removing defendant to remove not only federal question, but also the otherwise unremovable state matter when joined with federal question. So it prevents the plaintiff from adding state claims in order to prevent removal. Distinct court or the district court has the discretion to accept state claims along with federal claims, or just a federal question claim if satisfied, or just the federal question claim itself. There, 1367C allows federal court to remand if state claims predominate. Removal is entirely vertical. Defendant removes to federal district court that covers original state court. So defendant can seek to transfer to another federal court once the action has been removed. Removal is considered waived if defendant takes a substantive defense action. For example, a counterclaim plaintiff before filing for removal. Waiver of defenses, subject matter jurisdiction is never waived, as we talked about. Personal jurisdiction, notice, service of process, and venue, these are all waivable. Their threshold defenses must be raised by a pretrial motion or asserted in the answer, or else they're taken as waived. So under Rule 12, any threshold defense you don't put in the first motion can't be raised in the second. Consolidation there. You use it or lose it. If you don't omit a threshold defense, you can't put it in the answer. If you omit a threshold defense, you can't put it in the answer. If you make a threshold defense motion and lose, go one with the case and subsequently appeal it. Go with the case, keep going forward. Rules for removal, remember you can only remove to federal court if it could have been brought there in the first place, and only to the federal district courts, geographically embracing the state court, so on the state court where the claim arose. Under 1441A, 1441C provides exceptions. Once whole case in federal court can remand issues where state law predominates, so you can remove from state law to federal courts, and the federal court can strike back down some issues where state law predominates. So one way street there, it's from the state court to federal court. Remember, not vice versa, state court to federal court, and be placed back, and it can be placed back in the state court system. If it was wrong to remove, the case is remanded back to the state court. So only defendant can remove 1441A. In this request, defendant gets a choice in forum shopping. With multiple defendants, all defendants must agree to the removal, except in 1441C. So case is removable only if there is federal subject matter jurisdiction. Don't look at personal jurisdiction venues as you do in except. Remember, no removal of a diversity case if any defendant is a citizen of the forum state. Alternatively, this means that you can only remove a diversity case if you are an out-of-state defendant. So if defendant is from Iowa, plaintiff is from Alaska, and the cause of action arose in Iowa, for example, then the defendant wouldn't be able to remove to federal court there in Iowa. It would have to be at some other state. Maybe it could be the cause of action arose in California, and that would be the easiest example, which that might be permissible. Entire case may be removed, and the district court may either determine all issues or it may remand. Once the case is filed, it must be removed within 30 days. And remember, matters in which state law predominates there, that's another example of what might be removed. Challenging subject matter jurisdiction, direct attack. You can do a motion to dismiss. It can be asserted at any time by any interested party. And collateral attack, general rule is that a judgment rendered by a court that lacked jurisdiction over the subject matter is void. Venue rule there, 1391. Venue is a determination of the judicial district in which plaintiff may bring suit. Venue is proper in a district where defendant resides. If all defendants reside in the same state in which district is located, then that is 1391b1. Any district in which a substantial part of the events or omissions giving rise to the claim occurred, 1391b2. And the fallback provision, if 1 and 2 don't apply, if no district in the U.S. satisfies the above, then it's any district where any defendant is subject to personal jurisdiction. Residency, remember, natural persons is their domicile. You can only have one for people versus corporations. You can have two or more. 1391c1, corporations in any district in which it's subject to personal jurisdiction for purposes of venue. Treat each district like a separate state under 1391c2. Residency continued if there is no district court. One, if a, like let's say, for example, if a corporate defendant has enough contacts in the aggregate to be subject to personal jurisdiction, California, but does not have enough contacts in any of the 4 individual federal districts in California to be subject to personal jurisdiction, any of them, the district within which it has the most significant contacts. So almost there. We'll skip a lot of these typed outlines that I have. Got about 4 more pages, and then we'll discuss some of the cards if we can allow before we move on to our next topic. So almost there. So we're gonna keep moving forward. We can do this. So close. I know. Thank you for bearing with me. We're almost there, about 4 more pages. And then we'll move on to the next topic. So venue transfer rule, a case may be transferred from one federal district to another federal district in the interest of justice if the transferee district is one in which the case could have originally been filed. Note, you can transfer to any district with proper venue, when you have personal jurisdiction and subject matter jurisdiction. Court in any party may move to transfer venue, but usually it's the defendant, since the plaintiff files in a specific court. Transfers are possible only within a judicial system, state to state or federal to federal. If venue in original district is proper, 1404A, then transfer is discretionary, convenience of the parties, witnesses, and or in the interest of justice. Court will look at where relevant events took place, location of evidence and witnesses, court docket loads, familiarity with applicable law, and forum selection clause, if any. In a 1404A transfer, the transferee court, the receiving court, must apply the choice of law rules that the transferor, the original court, would have applied. Rationale is that a change in venue should not change the law to be appointed to the merits of the case. If venue in original district is improper, then 1406A. Then court shall dismiss the case, or if in the interest of justice, transfer to a proper district. In a 1406A transfer, the transferee court, the receiving court, applies its own choice of law rules because the transfer court is not a proper venue. Venue generally, it refers to a place within a jurisdiction where an action can be brought, adds a convenience factor beyond personal jurisdiction and subject matter jurisdiction because we focus on where the event occurred. There's no constitutional authority. Article 3, Section 2 didn't create the district courts, Congress did. So 1391A, when original jurisdiction is based on diversity, venue is proper. Any judicial district where defendant resides, if all defendants reside in the same state, resides for individuals is a domicile. It's a physical presence plus intent to stay. And the resides for corporations is any judicial district where corporation is subject to personal jurisdiction when the action begins. Now you pretend each district is a separate state. If the state has multiple districts, then you pick one with the most contacts. Where any substantial portion of the events, omissions giving rise to the claim occurred also, or anywhere where the defendants would be subject to personal jurisdiction when the action begins. So 1391B, not diversity, same as A except number 3, any judicial district where defendant may be found, Under venue transfer, this benefits the defendant. Plaintiff brings claim. 1404 levels a playing field. This is a lateral move, not removing, just changing venue. For 1404A, for the convenience of everyone involved in the interest of justice, suit can be transferred to any other court where it may have originally been brought. Now, there are two ways of convenience factors. Number one, private interest for convenience of parties and witnesses. This is the ease of access. This is ability to compel witnesses, availability of evidence, cost of compelling witnesses, possibility of the site where the claim arose or where the accident happened. And then we also think about public interest. So we balance private interest or public interest. Where in the interest of justice, we might think of administrative difficulties for the trial, in the location, burden of jury, commonly unrelated there, or community's interests in a leading trial, local interest in resolving controversies, or overburdensome courts. So remember, for 1406, court waiver of defect there. If a venue is improper, court can either dismiss or transfer to proper venue. Transfer the proper venue and depends where the action under 1391 analysis, the original could have been brought. Venue statutory, allocation of cases to promote judicial economy and convenience of parties for federal question. Under 1391, defendant resides if all defendants are the same, substantial party of events, personal jurisdiction diversity where defendant may be found. Substantial part can be minimal in the Bates test, receipt of collection notices, threshold matter, but only after jurisdiction is established. Waived unless asserted under 12b3. So local action rule for property seems to be outdated there. Cross complaint against out of state for making where the damage is property, for example. There, you can still opt in 1391, 1392 based on sovereignty of state, adjudicating to adjudicate regarding its own property, but no longer difficult to apply other states' laws. Harder to keep defendants within a state, should protect citizens from their crimes in other states. We think about other actions that can occur in different places by nature. Transfer of venue, 1404A, for convenience of parties, witnesses, and interests of justice, transfer to any district where it may have been brought. Under the Hoffman case, patent infringement suit in Texas to have jurisdiction. Remember, determined at the time of filing, so potential for waiver does not matter. In diversity cases, use of law, transfer court, unless it has no jurisdiction. Multi-district litigations can be transferred under 1407 for pretrial hearings and then should be transferred back. Also, we have all of these rules for proper venue. Venue deals with allocation of a case within a court system that has jurisdiction over that case. Venue challenge must be raised by defendant early or it's waived per 12b3. Jurisdiction must establish first over the parties. Venue is waivable because it is an issue of allocation or convenience, constitutional basis. There are three questions to determine proper venue there. And there, venue in federal court actions, 1391, which court shall try the action. Does the court have venue under the statutory structure? Under 1391A, diversity cases may be brought in only in federal court, federal question, and move diversity cases there may be brought into federal court where the defendant resides, if defendant resides in the same state. Substantial probability of where evidence is, or if not on its venue there. So we'll also look at note on corporations and aliens for purpose of venue. Corporations residing in district at state of action. Aliens may be sued in any district court where there's a state action is falling. Removal says that when a case is removed to federal court there. And also local action, where in cases involving land, action must be brought in the state where land is located there. And so if it's located in more than one state, then venue is proper in both. That is where if a local action can't be brought because of some sort of lack of inability to have that action It's where we look to where the defendant resides. If the court has venue on the court transfer, 1404A, we look to the convenience of the parties. Motion to transfer almost invariably made by defendant and burden on mouvant to show why transactions transfer from one to another could have been brought. Law of transferring court must apply. Transfer court must apply. Generally only applicable to diversity cases. There's a consensus against applying this to federal question cases. 1407 allows cases with same CNOF to be transferred to another court or consolidated for pretrial hearings. Cases must be returned to transfer court for trials unless you get some invocation of 1404A. The court has venue. Are these situations where we should transfer it? Look to forum non-convenience. So venue and transfer, remember here, fallback venue is any location where court exercises personal jurisdiction over defendant. Rarely applies because must be after venue in which the case is brought. We looked at where any defendant resides, or for natural purposes, aliens lawfully admitted domicile, or for corporations, anywhere court has personal jurisdiction. If there's more than one district within a state, then appropriate venue is any district within that state that satisfies that. Venue is appropriate where 28 U.S.C. 1391. A substantial part of the of that gives rise to the claim occurred, or a substantial part of the property subject or action. Multiple venues can be correct. Does not imply that a singular place is correct, because it essentially required trying to figure out the venue. See Bates, that case where the court found that venue is appropriate in the district where a plaintiff received a collection letter that violated the statute giving rise to claim. Additional venue specifications where defendant is an officer or employee of the U.S. or a foreign state. Change of venue transfer. You may change to any venue that could have originally been brought and to which all parties consented. You must satisfy both could have been brought in interest of justice. Convenience of parties, witnesses, condition could have been brought applies to at the time the case was where convenience justice alone is insufficient. Filed just because defendant later raised personal jurisdiction objection doesn't mean that the case could have been brought. Court retains discretion to reject a jurisdiction to which both parties consented. Court may either dismiss or move cases that are filed in improper venue. No obligation of the court to address venue complaints not made in timely manner. Jurisdictional dismissal is without prejudice there. 12G, if you don't raise a motion to dismiss due to lack of venue, then the right is waived. Choice of law. So the rule there is absent federal or constitutional questions, a law to be applied is the law of the state which the court sits. That's the Erie Doctrine. Rejects the federal common law adopted in the Swift case. Procedurally apply federal law, not state rules of civil procedure. Post Erie there. No transcending body of law to provide a basis of consistency of application for the standard. Conflict of law rules. Federal courts must apply conflict of law rules of state where they sit. A state could apply its substantive law in a case so long as the state had significant contacts or significant aggregation of contacts with parties or transaction. So encourages forum shopping because state will likely end up applying its own laws if they have personal jurisdiction over the parties. Change of venue cases, court applies the substantive law, laws of the state in which the action was filed, not the court to which it transfers. Potentially maintains the advantage of the plaintiff to choose its own forum. Under venue, to determine if a court is competent to hear a case, three things must be satisfied. Court must have personal jurisdiction over the defendant, subject matter jurisdiction over the defendant, and the court must be the proper venue. That is, the case, it's where the case in the trial is bearing some relationship to the claims asserted or the parties to the action. Venue rules, all venue rules are statutory there. And they have to apply a constitutional analysis there. So 1391 is diversity cases. Venue can be laid where any defendant resides. Venue can be laid when a substantial part of the events giving rise to the claim occurred. Fallback provision, if any venue cannot be laid anywhere else, it can be land in any district having personal jurisdiction over a defendant. 1391B, non-diversity cases or cases not based solely on diversity. 1 and 2 are the same there. Fallback provision in 3, if venue cannot be laid anywhere else, it can be laid in any district in which any defendant can be found. 1391C, it covers corporations which are deemed to reside in any district having personal jurisdiction over the corporation. Ford is a citizen of Delaware and Michigan, but resides in every district since it sells cars in every district. Important points before we move to forum nonconvenience. Venue is considered a personal right and can be waived through failing to raise it in its response to plaintiff's complaint, or through a forum selection clause, like in Carnival. These are general provisions that apply except as otherwise provided by law, like in removal, and in other areas, like patent infringement, covered under 1400, I think. Distinction between local and transitory activity actions. Local actions involving real property, in which venue is they're based and distinct there and lies in where the land lies. Transitory actions are everything else and are subject to the above rules. Where a substantial part of the claim occurred implies that several venues may be correct ones. Transfer. Definition. If a venue is not a correct one, or there is a more correct one, then transfer is one that shifts the case to a different venue within the same system, such as the federal system or part of the states, if it's the state systems. There are 2 transfer statutes. 1404A applies when original federal court from which the case is transferred is a proper venue. Transfer is based on convenience and standards of justice and is entirely in the judge's discretion. So there's a 4-part test where we look to the convenience of parties, convenience of witnesses, interests of justice, and could have been brought in the first place by the plaintiff. Personal jurisdiction, subject matter jurisdiction, venue. In the Hoffman case, plaintiff there sues Hoffman in Texas federal court for patent infringement. Held 1404A only allows transfer to venue. Plaintiff could originally have brought the action, remanded back to Texas federal court. Law follows to new venue. Since a federal court will apply the law of the state in which it is located, new transfer court will make the transferee court will make the transferor court in application of substantive law there. And so that's an example. There's a Bates case where venue is proper where a substantial part of the events giving rise to a claim occurred. Venue is proper under the Fair Debt Collections Act in a district where an allegedly offending letter is received. Venue exists in a district where debtor lives and which collection agency is denied for payment was financially received by the debtors. And the treatment of debt not occurred in that district. So in the Hoffman case under 28 U.S.C. 1404A, a federal court can only transfer a case to act where the plaintiff would have originally brought the case. The power of district court to transfer an action to another district depends not upon the wish or waiver of defendant, but rather upon whether the transfer district was one in which the action might have been brought initially by the plaintiff. Remember the forum nonconvenience rule. If there's a far more appropriate court in which a case should be heard, separate judicial system, foreign country, etc., the court in which the case was filed may decline to exercise its jurisdiction and dismiss the case. There are factors under Piper. We look to public interest factors, administrative difficulties of keeping the case, local interest in litigating the case, which court may have expertise and subject, etc. Private interest factors where evidence and witnesses are located, ability to and expense complied witnesses to trial, etc. So in the Piper case there, the California Supreme Court, they saw negligence and strict products liability. And the Erie holding is important. In diversity cases, federal courts must apply state substantive law and federal procedural law. But what is substantive and procedural? Twin aims of Erie are to discourage improper forum shopping and to ensure equitable administration of the law so that you get the same result depending on, regardless of where you file a suit. So here's a summary of Erie doctrine and forum nonconvenience there. So forum nonconvenience, a doctrine used by the court when venue is proper but not convenient. Most frequently used in international cases where our laws don't apply but our doctrines do. Factors to consider: is there an alternative forum? Balance plaintiff's original forum there, public interest factors, private interests. Usually there is there's deference to plaintiff's choices, but it can be overcome when Gilbert factors clearly point otherwise there. Ascertaining the applicable law. What law do we use when we go to federal court for diversity jurisdiction? Rules of decision: diversity cases require federal courts to apply state law, except where Constitution and U.S. treaties apply. Rules Enabling Act: SCOTUS has the power to apply FRCP and U.S. district courts, exception unless application of such rules abridges, modifies, or enlarges any substantive law, substantive right. Erie Doctrine: used when state and federal laws conflict. Federal Doctrine: Erie, mandating that federal courts in diversity jurisdiction apply state substantive law, which includes state statutes and case law. Purpose is to avoid forum shopping and prevent unfairness to litigants who can't choose their forum, and that old way federal courts in diversity jurisdiction could ignore the state common law in favor of general common law, but not anymore. We have a 3-step analysis for the Erie Doctrine. We first ask, is the state rule a matter of substantive law? If yes, then Erie requires state law to be applied. Substantive law is a law that is bound up with the core rights or obligations defined by procedural law, which is by state law. And procedural law is about the form or mode of enforcing a state's substantive right. That's where we use FRCP and the rules of federal court practice. And then you ask, is it a rule of federal court practice or a rule of civil procedure? If court practice, go straight to Erie analysis. If rule of civil procedure, is there a direct and unavoidable conflict between federal rules and state rule? If yes, then apply the state rule. If no, then apply Erie. When ignoring the state rules substantially affect the outcome of the case, if no, apply federal law. If yes, apply state law unless it would encourage forum shopping. Its only outcome is determining if it encourages forum shopping under Byrd. Ascertaining the applicable law, state law in the federal courts there. Tradition: use state statutory law, not the common law there. Interpretation of rules of decision in 1652. Creation of general common law to find the universal truth through horizontal uniformity. However, Erie Doctrine, federal court and diversity action must use state substantive law. As we talked about, no universal truth. Instead, negligence rule, for example, versus general rule. Then includes state common law and perpetuates common law. There you go. Substantive versus procedural distinction. Outcome determinative test. State law should be used if federal law would change the outcome. And so statute of limitations is an important part of state interests there. Federal courts should act as another state court in this forum. Vertical uniformity. Tolling of statute of limitations is state law. Any change in outcome or just outcome that is dispositive of the case. Then twin aim of discouraging forum shopping, promote equitable administration of laws. And use a balancing test. You weigh the state interests versus countervailing federal interests in Byrd. And the jury-judge distinction under influence is not there. So outcome determinative has to be clear at the outset, plays a role in balancing tests. And so the flowchart: does a FRCP control issue there? If yes, is the FRCP in question within scope? Then no, then state. Is FRCP in question constitutional under due process, necessary and proper clause? If yes, federal. If no, state. And then as we talked about this. So Rules Enabling Act, remember, the Rules Enabling Act cannot abridge, enlarge, nor modify substantive rights. Rules of procedure from automatically if they're constitutional, valid, and applicable under Hanna. Under the federal service rules, greater than state procedures, validity there, applicable based on how broad the rule is. Tolling of statute limitations is not compelling, The Stewart case we'll talk about. And then remember the protection against form, and then remember the conflict with the forum selection clauses. It may be possible to split the procedural and substantive elements of a conflict. New York law for review as applied. There's reexamination, choice of law. Absent federal or constitutional questions, law to be applied is the law of state, which is where the cause occurred. Rejects the federal common law approach in Swift. Procedurally apply federal law. State rules of civil for for post for Erie after that Swift case. Conflict of law rules. Federal courts may apply the conflict of law rules in which they sit. A state could apply its substantive law in a case so long as the state had significant or a significant aggregation of contacts there. Change of venue cases. Court applies the substantive law of the state in which action was filed, not the court to which it was transferred. Threshold question, is there another forum in which the case could have been brought? If no, the forum nonconvenience motion fails on face. The Piper case, plaintiff may not defeat a motion to dismiss for FNC merely by showing that the substantive law in the alternative forum is less favorable to him than the current forum. Exception, cases where the remedy provided by the alternative forum is so clearly inadequate or unsatisfactory that it is no remedy at all. Court accepts possibility that changing forms may affect outcome, but says need to weigh in on other interests like balancing tests of those factors that determine forum nonconvenience, and finding a plaintiff's chosen forum burdensome but not unfair is still sufficient for FNC. And that's where we look at private interests and public interests. And then primary application of forum nonconvenience, necessary to move from one state court to another state court by way of dismissal due to change of venue option, only reason to use in federal courts to leave the U.S. So remember, in the Piper case, plaintiff may not defeat a motion to dismiss for forum nonconvenience merely by showing that the substantive law that would be applied in the alternative forum is less favorable to him than that of the present forum. If the state chosen by plaintiff has the only adequate remedy for the wrong alleged, motion to dismiss for FNC may be desired. Here, there are heirs of the plane crash victims. They're suing for wrongful death in U.S. courts. Recognize wrongful death as a cause of action generally known to more favorable to plaintiffs than Scottish courts. Fact of a substantive law being less favorable to plaintiffs in alternative form should not be given conclusive or even substantial weight in applying the doctrine of forum nonconvenience. So in Erie, federal courts sitting in diversity must apply state substantive law, whether statutory or common law. So although the 1789 Rules of Decision Act left federal courts unfettered to apply their own rules of procedure and common law actions brought in federal courts, state law governs substantive issues. State law includes not only statutory law, but case law as well. In Guarantee Trust Co. versus York, a federal court exercising jurisdiction based strictly on diversity of citizenship must abide by any state legal rule that would be outcome determinative if held in the state court. So Supreme Court developed outcome determinative tests, whether state law substantive. State statute of limitations applies in federal diversity cases, where disregarding it would significantly alter the result of the litigation as compared with the outcome had it been tried in state court. The proper method of determining if the state statute of limitations will be applied in federal diversity cases is to ask if the federal court was to disregard it, would doing so significantly affect the result of litigation. So where a state statute that would completely bar recovery in state court has significant effect on the outcome and is determinative of the action, even though the suit is brought in equity, the federal court is bound by state law. So the last page of our first half of civil procedure. So outcome determinative test, if applying the rule determines the outcome, it is substantive, apply state law under Guarantee Trust. Byrd balancing test, you have to balance the federal interest in applying the federal rule versus the state interest in applying the state rule. Is there a federal rule or directive directly on point? Is there a direct conflict or collision between the federal procedural rules and the state rule? If yes, if there's a conflict, then we'll apply federal. Was a federal rule meant to occupy the field? If yes, then apply the federal rule. In Erie, framework for analysis, is there a federal rule directive directly on point? If yes, apply it so long as it's valid. Is it outcome determinative? Look at the Byrd balancing test. Always ask, does applying the federal rule violate the twin aims of Erie? Will it lead to improper forum shopping? Or will it lead to inequitable administration of justice? Under Byrd, the rule that we have is the federal policy of having the jury answer questions of fact prevails over state rules that would interrupt the judge or jury relationship in federal court. The rule there is state decisional law do not apply in federal diversity cases, where it allowed a judge and not a jury to determine a factual issue. The general rule there, the Erie Doctrine requires that federal courts in diversity cases, respect definition of rights and obligations created by state courts, but state laws cannot alter the assorted characteristics and functions of the federal courts, and the jury function is such an essential function, the essential characteristics provided for in the 7th Amendment. In Hanna, for service of process in federal diversity actions, Federal Rules of Civil Procedure is the appropriate standard of process because a rule does not exceed congressional authority or constitutional boundaries of jurisdiction. So in that case here, in Hanna, conflict between federal rules and the state procedural law over service of process, their state law requires something else. So Erie was not intended to circumvent federal laws with state laws. Broad rule there is that FRCP governing service of process apply to federal diversity cases, notwithstanding conflicting state rule. The outcome deterrent test cannot be read without reference to the twin aims of the Erie Doctrine, discouragement of forum shopping, and avoidance of inequitable administration of the laws. So the Erie Doctrine mandates that federal courts are to apply state substantive law and federal procedural law, but where matters fall roughly between the two and are rationally culpable of classification as either, the Constitution grants the federal court system the power to regulate their practice in pleading. So that is the first half of civil procedure. I think we'll skip a lot of this. We talked a lot about these cases. This is just like my own summary of like the rules that we talked about and the holdings. And next we'll move on towards pleadings and joinder and all these other fun rules for the second half of civil procedure.